This is just a sample of the ingredients that go into Krisanne Hall's genuine constitutional elixir. This excerpt is found near the first of a larger work concerning the Coalition of Western States, of which Krisanne Hall is their so-called legal advisor. The excerpt will play in a moment, or click on the yellow square to go to the larger work now. The Coalition's most able, quote, Constitution, unquote, propagandist is their so-called legal advisor, Krisanne Hall. In the following excerpt of an episode from Oregon Public Broadcasting's This Land is Our Land, the occupiers they refer to were armed militants led by Ammon Bundy, who took over Malheur National Wildlife Refuge in Harney County, Oregon, in January of 2016. Bundy is an associate of the Coalition of Western States in Krisanne Hall. From OPB's This Land is Our Land.
So Conrad, we have another listener question. It's about the Constitution, and I want to bring in OPB reporter Amanda Peacher for this because she spent so much time at the Malheur Refuge listening to the so-called patriots talk about the Constitution. Hi, Amanda.
Hello, Amelia and Conrad.
So let's hear that tape from the listener, and then you and Conrad can tell us a little more.
Hi, OPB. Will you have an investigation or information on the particular constitutional beliefs of the occupiers? It seems much of the event can be traced to an interpretation of the Constitution they carried in their pockets. Thank you.
Thanks, Matt. We thought that was a great idea. The pocket constitution that you're thinking of is called the Skousen Constitution. And there's a reason why it's handed out like candy at fairs and parades these days. We'll talk more about the Skousen Constitution in just a little bit.
But first, let's talk about the occupiers' specific interpretation of the Constitution. There are two clauses of the Constitution that are important to understand here: the Enclave Clause and the Property Clause.
And here we're going to get a little law schooly, so stick with us.
We promise it's important.
First, let's talk about the Property Clause. For you Constitution buffs, that's Article 4, Section 3, Clause 2.
The Property Clause gives Congress the power to make all needful rules and regulations related to territory or property belonging to the United States. Basically, this is the clause that most people point to when they say the federal government has the right to own and manage lands.
But the occupiers point to another part of the Constitution, the Enclave Clause, to say that the federal government does not have that right.
If you want to follow along in your own pocket constitution, the Enclave Clause is Article 1, Section 8, Clause 17.
And it was quoted over and over and over again by the occupiers. Here, for example, is defendant Jason Patrick reading the Enclave Clause to me from his very tattered pocket constitution back in January.
To exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as may, by secession of
And it goes on with specifics from there.
Basically, the Enclave Clause is 1787 speak about the District of Columbia. The occupiers quote the clause to argue the federal government can't own land outside of Washington, D.C., unless it's to build, say, a fort, in which case they'd go through state lawmakers to buy land for that fort.
So essentially, what we have is the Property Clause pitted against the occupiers' interpretation of the Enclave Clause. We checked in with Professor Michael Blum from Lewis and Clark Law School about these two clauses, and he said it's pretty clear how they interact.
They both exist in the Constitution, and the Supreme Court has said that the Enclave Clause doesn't limit the Property Clause.
So, in other words, Blum says, the Enclave Clause's mention of those 10 square miles of the District of Columbia doesn't mean that the federal government can't own land beyond that, based on the interpretation of the Property Clause.
And one of the cases that settled this matter, not surprisingly, started in the West. It happened in Utah about 100 years ago.
Well, the case I'm thinking about was a case called Utah Power and Light v. United States. The utility in that case said that they weren't subject to regulation by the Forest Service on forest reserve land because that land had not been purchased with the consent of the state. And the Supreme Court rejected that argument. That's the same argument that the people carrying around the Constitution in their pockets are making.
And Blum says that the Enclave Clause has never been interpreted by the courts in the way that the occupiers read it. But that doesn't change the fact that the occupiers' interpretation is spreading.
The federal government has no authority to own any land outside Article 1, Section 8, Clause 17.
That's Krisanne Hall in a YouTube video from January. She's a former prosecutor from Florida who now travels the country giving talks about the Constitution. You hear the occupiers and others in the Patriot movement referencing her a lot.
And her talks are popular. She's been to Oregon a few times since the occupation, and she always draws a crowd. One of her arguments is that the property clause is only meant to refer to territories.
Let's be very clear about this territories thing. Go read the Constitution. Territory is capitalized. This is a proper noun with a specific meaning, and the federal government owns no territory within the continental U.S.
But there's a very clear problem with what Hall's saying. The Constitution is full of capitalizations of nouns that we wouldn't necessarily capitalize today. And there's not necessarily a reason for it.
They were all about the uppercase in the 18th century. Words like election and profit and money are all capitalized in the Constitution. But Hall seems to be successful because she's seen as an authority figure. She has a legal background and is convincing a lot of people.
But to Blum and to most mainstream legal scholars, the legal arguments from the occupiers are just so outside the norm, they don't take them seriously.
But at the same time, there's a pretty strong movement afoot to sort of take back the Constitution that's gaining momentum across the American West. In one sense, it's tied to this larger frustration with the federal government. If you're someone who wants to see federal lands be turned over to local control, then the occupiers' interpretation of the Constitution might resonate.
Right. It's like confirmation bias. People are more willing to believe information that supports their point of view.
But at the end of the day, Blum says these constitutional arguments around the Enclave Clause have no chance of going anywhere in the court system. This debate is done and done.
They've set themselves up as judges because they're not paying any attention to the judges who've looked at this and have, over the centuries, interpreted it. So I guess the one lesson would be, from the occupier's perspective, every individual has final and authoritative interpretations of the Constitution. To me, that's complete chaos. Individuals should interpret the Constitution, but the final word comes from the courts. And the final word has been very consistent concerning the ownership and control of federal lands in this country for a long, long time, longer than anybody has been alive.
So we probably won't see this argument going anywhere in the legal system, but on the political landscape, that's another matter. Some of the same groups pushing this interpretation of the Constitution are also working on state bills to try and get federal lands turned over to states or counties. So this interpretation of the Constitution is definitely connected to the broader federal lands transfer movement.
All right, moving on.
OPB is being generous when they say Krisanne, the coalition's legal advisor, has a legal background. In 2010, she quit her job as a Florida prosecuting attorney. But to this day, she claims she was fired for her Tea Party politics, which of course endears her to her followers. Today, she is not licensed to practice law anywhere in the United States, not even in her home state of Florida. Boasting of being a constitutional attorney, as she does on her homepage, you would think she would at least have a background in constitutional law, which she does not have. As for her drawing crowds, so did the snake oil peddlers, and as we know, the crowds did not make the claims of the peddler any more genuine. Two of the peddlers of Krisanne's snake oil, besides the Coalition of Western States, is the Oath Keepers and the Constitutional Sheriffs and Peace Officers Association. Stuart Rhodes, founder of the Oath Keepers, and Richard Mack, founder of the Constitutional Sheriffs, were both involved in the establishment of the Coalition of Western States in 2014.